Hi, welcome to Mondays with Melissa. Today I want to talk about a very specialized type of guardianship called a 17A guardianship. And this is a guardianship that takes place when a disabled individual is about to turn 18. So we do like to get this started prior to the 18th birthday. It's important. But once somebody turns 18, there's no one with the legal authority to handle anything for them anymore, handle their finances, help them make healthcare decisions. So we know we take our child to the doctor. Sometimes once they're 18, you're not allowed to go in with them. Well, for a child with developmental disabilities, this can become an issue at the age of 18. So the parents will bring a guardianship proceeding prior to the 18th birthday. So when that child turns 18, the parent can still remain in charge and a part of everything that's going on in that child's life. This guardianship is different than a guardianship that we might bring for an older person who has a mental incapacity, or even a younger person who is injured in an accident, has a traumatic brain injury. This is for people who are disabled from birth, so that they have a developmental disability from the time of birth, and at the time they turn 17, we want to start thinking about putting their parents in place as guardians once they're 18. So if the parents are still married and they're both going to be guardians, or even if they're not married but they're still in agreement to be guardians, much of this is done with paperwork. This is a very diagnosis-driven type of guardianship. So we need to hear from the child's primary care physician, if they have a psychiatrist, a neurologist. Depending on the situation and what the developmental disability is, we have to look at the team of doctors and see who we need affidavits and information from. And that's what we present to the court. Now, the court does require a hearing, and in many cases, they do require that the child be part of the hearing. And sometimes that can be very disruptive for the child, so we do have to work through those things. And many of them are still done online. But again, it's a very diagnosis-driven type of guardianship. So it's important to make sure that we have all of the medical information that we need, that we have evidence of the diagnosis, and that we have records and notes that the doctors have taken to make sure that we can get the guardianship approved so that the parent can, of course, continue to make decisions for the child. I have one case where there was a child in a residential group home and they wanted to leave. So, once they turn 18, again, there's no one with the legal authority to say, you have to stay here. So going to the doctor or signing yourself out of a hospital, those types of things at the age of 18 are things that individuals are allowed to do. So it's really important to make sure that that guardianship is in place. Now, there's another type of guardianship when you're talking about your children, and that's for anybody who has a minor child when they're doing their will, to make sure that they have guardians named for their minor children if something were to happen to them, to both parents, while the children are still minors. So this doesn't have anything to do with developmental disability. This just has to do with making sure you have a will, so that if something were to happen to yourself and the other parent of the child or children, that you have an appropriate person in place that's going to then act and take care of that child and help raise that child, live with that child, whatever you determine and decide is best, whether the child goes to live with them or they move into your home. These are all things that we discuss at the initial consultation. Thank you for watching. Please put any questions into the comments and we'll see you next week.